Supreme Court of Florida is now in session. Please be seated.
We now take the third case on today's docket, U.S. Bank National Association versus Anthony Irish.
May it please the court, my name is Matt Canigliaro. I'm with Carlton Fields, and I'm here today on behalf of the petitioner in this case, U.S. Bank. A judgment entered without subject matter jurisdiction is void. The Fifth District avoided declaring the dismissal order in this case void by redefining subject matter jurisdiction in a way that conflicted with a century's worth of case law. Subject matter jurisdiction is not simply a yes or no question regarding whether a court has authority to hear a type of case. It includes multiple aspects. It begins with a pleading that raises issues, that asks for some type of relief. We add to that.
Well, on that aspect of it, how does that square with our decision in Lemaire?
I'm sorry?
The point about what's asked for in the pleadings, how does that square with our decision in Lemaire?
Your Honor, in that case, the court essentially did what this court said long ago in Malone, which is recognize that subject matter jurisdiction does not depend on the sufficiency of the allegations. Subject matter jurisdiction is about the power of the court, and there are certain basic aspects that define the power of the court. And so what the court said in Lovett was that when certain pleadings are filed, issues are raised, and certain relief is requested, to go beyond those matters into something different is to exceed the court's subject matter jurisdiction. And a judgment on such other matters would be void. That's what the court said in Lovett. In the Lemaire decision, the court was dealing with a circumstance where the pleading arguably did not state a cause of action. And the court said, we're not going to look at that. If relief was requested, there was a default, relief has been ordered consistent with what was requested, that if there is error in that decision, then that's simply, well, the court said it was voidable, but essentially what the court meant was that's error, and it can be raised.
How did we reason our way to that conclusion in that case?
Well, I think consistent with what the court said in Malone long ago. The court essentially reasoned that the sufficiency of the allegations does not determine voidness. However, the relief that is requested can determine voidness. It plays an integral role in subject matter jurisdiction. And in this particular case, the relief that was requested of the trial court, as the trial court broadly construed this handwritten letter, was to vacate the judgment in favor of U.S. Bank.
Well, let me ask you this. This case, there was a summary judgment entered, correct?
Yes, Your Honor.
Okay. And in the order, what did the trial judge do other than enter the summary judgment? Well, I mean, was there some retention of jurisdiction in the order?
The original judgment retained jurisdiction for purposes of entering a deficiency judgment.
Okay.
And otherwise, it dealt with the typical.
It said to enter further orders as are proper, including deficiency judgments. It doesn't say that it was limited in what those further orders would be. And then right after that, there was an order to go to mediation. I mean, we're here not because whether, maybe U.S. Bank could have objected to go into mediation and say, listen, I already have my final summary judgment. I don't need to go to mediation. We're talking about something that happened years later that now is being objected to. Isn't that different than a posture of saying that they shouldn't have, in their continuing jurisdiction, have ordered mediation?
Well, Your Honor, there are multiple problems with the dismissal order in this case. And yes, we have,
But no, let's just talk about, because you said there was no subject matter. Let's talk about what Justice Quince was asking about what the final summary judgment said. You said it just provided for them to be able to enter a deficiency judgment. But I said, doesn't it also say to enter further orders as are proper?
Your Honor, I believe that language is common in foreclosure actions. It's not meant to destroy finality, and it's not meant to leave the door open for the court to enter any order it would like on any subject.
Well, let's just start with what happened after that judgment was entered. The court then, some days later, ordered mediation.
Yes, sir.
If your client felt at that point they had a final judgment that was executable, and they even set, they had, I understand,
Yes, sir.
a sale date, correct?
Yes.
So at that point, shouldn't your client have filed something saying this case is already resolved, we don't need mediation, something? Shouldn't there, if the court didn't have the authority to do that, did the court have the authority to do that?
We maintain it did not, Your Honor.
Okay, so
but-
if the court did not have the authority to enter that order concerning mediation, shouldn't your client have filed something telling the court, mediation is not appropriate here, we already have our final judgment, the sale is set for such and such a, but none of that happened, correct?
Your Honor is correct. Two responses. First of all, it's common in these types of cases for the parties to be willing to talk. And that's what happened in this case. And that actually resulted in the foreclosure sale being canceled.
At your client's request?
Yes, Your Honor, and consistent with the mediation that was held. But ultimately, even if the mediation order was within the court's authority, there are still two more fundamental subject matter jurisdiction level flaws with the dismissal order in this case. And the first is it went beyond the relief that was requested by the pleading, which here would be that letter construed to be a 1.540 motion. And second, that letter came more than 1 year past the 1.540B3 time period.
Well, what's confusing to me is typically when you have a civil case like this and even a foreclosure case where you have a mediation, you have an agreement, typically that agreement says, okay, this is the deal between the parties, this is the contract, this case is over, you have a dismissal, and then any remedies by either party is going to be enforcement of the contract. Why didn't that happen here?
Your Honor, we never got to that point in this case. There was an understanding reached at the mediation about how things would proceed, and then, as the record shows, things just sort of fell apart a bit after that.
But didn't the record indicate that there was an agreement between the parties, just that the document itself was not filed with the court? That's what I read. Is that incorrect?
No, Your Honor, that both of those statements are correct, but there's more to the story, which is that the agreement was what you'd almost call an agreement to agree. It was an agreement to proceed that she would apply for some relief that could reduce her monthly payment. And we would stop the sale and allow that to happen and sort of see what came of it.
Was there an agreement or not?
Well,
Was there an enforceable agreement between the parties?
There was I'll answer yes, Your Honor. There was an agreement to continue this road of exploring
Did the
things.
enforceable agreement between the parties speak to the dismissal of this action?
No, Your Honor. And I think that becomes the key point, that this was not a situation where at some mediation the parties resolved this matter. It's not what happened at all.
Well, the part of the problem is here, in the context here, is when you talk about things breaking down, the bank kind of disappears from this process at a certain point. Isn't that correct?
And we've been candid with troubles with counsel led to
Well, I
that.
understand that, and that's unfortunate, but it's a reality. But, banks have responsibilities like other litigants, and one of the responsibilities is to pay attention to what's going on. And it strikes me as when you're talking about how long the other party here waited to do something, how long did the bank wait to challenge what the bank is challenging? here before us.
It took us several years to appreciate what had happened here, Your Honor. And when that occurred, we came forward with a 1.540, arguing that the dismissal order was void on multiple
But
grounds.
when you say to appreciate what had happened, you just didn't pay attention to what had happened. You know, now, maybe that's counsel's fault, not yours, but other counsel's. But the people working for the bank and responsible to the bank just let it go, just dropped it. And you talk about the finality of judgments and interest in the finality of judgments. I think I heard you talk about that. Well, that kind of rings hollow here when you're coming in low these many years later to challenge that. So, but in that context, let me ask you about section 702.07 and how that plays in here. And again, that's not something that's been talked about in the brief, but it's there. It's in the statutes. And it seems like it might have some possible relevance to the core issue here of the actions taken by the circuit court.
Ultimately, it should not, because in the only case law to discuss that statute in this context, the case law has made clear that...
Well, that's not our case. I'm not, I'm more interested in you talking about the text of the statute.
Well, the text of the statute says that the court has jurisdiction and can act on foreclosure matters.
Until the sale occurs, right?
Yes, Your Honor. And
no time limit at all. If it's before the sale, and maybe you could argue about exactly what constitutes the sale, but here, there's no question that nothing had happened that could possibly be characterized as the sale, right?
no, Your Honor. Nothing had happened that could be characterized as the sale. What we do have, though, is Rule 1.540, which is what provides the mechanism for getting relief from judgments. And the statute...
But since when do rules of court change the scope of statutes?
Well, they don't necessarily change the scope here, but what they do is put some constraints on how things operate. And here, as
substantively? Substantive constraints? Can a rule of court place a substantive constraint on a statute that was enacted by the legislature?
A rule of court can place the equivalent of a subject matter jurisdiction constraint on a court in the sense of a time limit, which is what 1.540 does here. It creates a 1-year time limit, and that time limit was exceeded. And multiple cases in Florida jurisprudence have made clear that after that 1-year period is up, the trial court lacks subject matter jurisdiction to address that 1.540 motion. And we cited the court authority where an order was vacated or a judgment was vacated. The case then proceeded to an entire new judgment. And on appeal from that, the appellate court realized what happened and said the original 1.540 decision was without jurisdiction and set aside everything to reinstate the original judgment. And so at a minimum, the time component of 1.540 should control here.
Well, even if the legislature says that the court has jurisdiction until to issue orders and to vacate the foreclosure until the sale has occurred, I'm just struggling to understand how the rule of court, the limitation in the rule of court, can override what the legislature has provided. Now, there may be questions about the scope of what the legislature provided, but just on the face of it, it seems to me, I'm struggling with that concept because it goes against kind of the general framework that our rules of court are procedural rules. They don't establish substantive requirements. And the legislature is charged with substance here, and providing for that extended jurisdiction in a particular category of case. It seems like to me the sort of thing the legislature could do.
Two responses, Your Honor. First, I believe the court can adopt rules of procedure that allow for a time limit like what we have here. And second, even if that's not the case, the notice...
Well, I'm not questioning the validity of our rule. I'm just questioning the application of it in a context where the legislature has made some contrary provision.
I appreciate that, Your Honor. But even if there is an application hurdle here because of the concerns Your Honor has referenced, that doesn't change the notice problem. That whether the statute provides for jurisdiction to set aside the judgment or dismiss the action or whatever, there still must be a pleading that comes in. Here, the motion was effectively a pleading that comes in and puts, in our case, the bank on notice that that's a potential outcome here. I don't want to minimize what happened, so I'll talk somewhat hypothetically. If someone did see this and actually made a conscious decision to think, I'm just not going to get involved. The judge has construed this to be a motion to set aside the judgment, and if that happens, we'll deal with it.
I don't see how that is any different than if somebody got a complaint and they said, that doesn't even state a cause of action. I'm going to ignore it. I don't understand why that would be different. And I think under Lemire, you can't do that.
Well, it's certainly the second part is correct, Your Honor. Under the case, you cannot do that. But if you have no notice, in this case, of not just the final judgment being set aside, but the actual action itself being entirely dismissed.
But
That seems entirely appropriate with the notion that a mediation agreement had been concluded. That's what typically happens in these cases. You have a dismissal of the action. And if you wanted to file something different on the enforcement of some agreement, file that.
Your Honor, that never occurred.
Or if you wanted to foreclose again, file that. Why are we even here? Why did you have to go back to get to that original action instead of filing something else?
The practical answer is what the court did by wiping out the action. If the court reads the order, you'll see there's language in there essentially bringing Ms. Anthony Irish current, wiping out all of the defaults that happened along the way. It's not simply as if the action was never filed. That's not what happened here. This was a much more burdensome order. And when we learned that, that's why we came in with a motion to set aside.
So the order substantively changed the amount of relief the bank could have obtained for a few years when they were in default.
Absolutely. And none of that was noticed to us through what happened here. And because of that, there is a lack of subject matter jurisdiction.
I know you're into your rebuttal time, but there's something that I'm curious about. It's curious that the docket sheet reflects that mediation was ordered at the summary judgment hearing, and that causes me to question how would you view this if the order that was entered said I'm entering final summary judgment, but I'm also ordering mediation, the parties shall go to mediation. What would you?
We would not be discussing mediation in our briefs, but we would still maintain the notice argument, the scope argument, and the timing argument. And for both of those reasons, there's a lack of subject matter jurisdiction underlying the dismissal order in this
Would that
case.
make it a non-final order if it?
I'm sorry, if it ordered mediation?
Uh-huh.
I don't believe so, Your Honor.
Okay.
I think the test of finality would still be satisfied. It's understandable that a court or the parties would want to mediate, but authority is a different issue. If I can save my time.
You've been talking about lack of notice. I want to be clear, make sure I understand on one point. You're not contending that you did not receive notice of the order of
No,
the
Your Honor.
trial
No,
court that you're trying to get set aside 4 years after it was entered.
No, Your Honor.
You got notice of that. And so ordinarily what parties do when they get an order like that they think is irregular or illegal or anything like that, they file an appeal. Isn't that correct?
Ordinarily, Your Honor.
Okay.
But if I could just clarify, when I say notice, what I'm talking about is relief beyond the scope of the pleadings, in essence.
Okay. Now, we have used up some of your times, but I will forward you the 4 minutes you requested for
Thank you, Your
rebuttal.
Honor.
Thanks.
May it please the court, good morning. I'm Joe Eagleton with Brannick and Humphreys, here today for the respondent, Elizabeth Anthony. I think we've touched on two separate but we think independent reasons why the trial court here was correct to deny the bank's motion to collaterally attack this order 4 years after it was entered. And the first is the one that was recognized by the 5th District, which is that the trial court's order was not void for what we've called capital S, capital M subject matter jurisdiction. And I want to get to that, but the first reason that the trial court was correct here is because initially, back in 2011, the trial court still retained broad post-judgment authority here to do exactly what it did, which was, as part of its equitable power, particularly in the foreclosure context, there's lots of things a trial court might be doing despite the fact that the final judgment of foreclosure has been entered. In fact, the final judgment of foreclosure, the summary judgment, is really just the first step in a longer process that may culminate in the sale of the property. And we know, for example, here that the trial court had the power, at the bank's request, to cancel or reset the sale of the property. We know that trial courts may issue writs of possession or may be involved in disputes about discovery over the property that's the subject of the final judgment of foreclosure. And we know, as you pointed out, Chief Justice Kennedy, that the legislature clearly has intended, under Section 702.07, for trial courts and foreclosure actions in particular to have the broadest possible authority to act in equity all the way up through the sale of the property. And so here, what we had was the trial court, at the same hearing where it entered this and signed this summary final judgment, clearly contemplating that the parties would go to mediation to discuss a global resolution to the foreclosure. And what they agreed on was that Ms. Anthony would apply for this program that could modify her loan to try to allow her to stay in the house and make some reduced payments. She did what the agreement required her to do, and it turns out that she was not eligible for this program. So she went back to the trial judge as part of the judge's continuing post-judgment authority to supervise this foreclosure case, and she said, "Judge, they told me to apply for this program, and now they're telling me I'm not eligible." And the bank said, "Oh no, well, reapply and continue making these reduced payments." So she did that. And again, she was told that she was not eligible. And so again, she reached out to the judge and she said, "What am I supposed to do?" And at that point,
So that we understand, she was pro se throughout this and even at the 5th District.
Yes, Your Honor.
Correct. So when what a lawyer might have done on her behalf as far as type of motion was, she did it in the, I guess, the
formal-
best way she knew how. But
right, she was writing basically letters to the
But
judge.
not copying the other side. She was
Correct.
not sending copies of what she was sending to the judge to the bank.
She was not, but there is no dispute that when the judge received those letters, he properly noticed the bank that he was going to hold a hearing. I don't think there's any dispute that the bank knew that a hearing was being set to address the issues that were part of her
Well, was there a
letter.
certificate on the, well, is the claim here that they lack notice? Again, I'm just trying to make sure, you're first addressing whether there was continuing jurisdiction.
Right.
And your argument there is both the order, but also the statute that Justice Kennedy pointed out, but did either side mention that statute?
No, it was not part of the briefing here. But I think it's, it's consistent, and I think Judge Altenberg referenced this in the Sterling Factors case, which we did cite in the brief. The statute really hasn't been talked about a lot in the case law, but certainly we know the legislature envisioned broad powers of the trial judge in the post-judgment foreclosure context. But, there's no doubt the bank knew that this was going on, or certainly should have known that this case was going on. It's their lawsuit. There's no claim in the record now, as far as I can tell, that they didn't know about these hearings that the trial judge was setting to address the issue. And if there was, and maybe this goes to the second point, but it's very difficult 4 years later, I think, to go back and try to reconstruct exactly what happened, which is precisely why these kinds of claims of error should have been dealt with in 2011 in the trial court and if necessary in the 5th District, because they could have been corrected at that time. Maybe the judge could have held another hearing. Maybe there could have been a limited remand. If there was any error, it could have been dealt with then. But what the bank can't do is come in 4 years after the fact and say, oh, well, there was this procedural mess up at the trial level, and now we get a do-over, basically.
Well, they're saying that the judge never had subject matter jurisdiction jurisdiction to do anything after the final judgment was entered, summary judgment.
Basically,
That's
yes.
what they, where they have to get to.
Right, right. And as the Fifth District pointed out, that's the only possible basis they have 4 years later, is to claim that there's no, what we've called capital S, capital M subject matter jurisdiction, because it's basically the only thing that would allow you to come along years after the fact and undo an order that you failed to diligently pursue and challenge at the time that the order was entered.
But the argument is, under the statute and case laws, they have, the judge reserves jurisdiction, there's continuing jurisdiction to enter orders as are appropriate. So it's really, again, would you address why their argument that there is no subject matter jurisdiction because the final judgment was limited in what it reserved?
Well, so I think that it's clear the court had some kind of post-judgment power. So the way that I construe their argument is to say the particular thing that the court did when exercising its post-judgment power here was outside the scope of what that power and authority was. And they have characterized that as a lack of subject matter jurisdiction. And I simply don't think that's supported by the case law at all, because what we're talking about is whether the trial court was right or wrong. It's clear that the court, that there were issues that remained in dispute to still deal with post-judgment. The sale hadn't been held yet. It's clear the trial court could cancel the sale. It's clear there were lots of things the trial court could have done. And so what they're saying is, well, this particular thing that the trial court did was not within its power or authority. And for the reasons we've talked about, we disagree with that. But even if they're correct, they had remedies at the time to deal with that. That doesn't mean that the order is void. It might be voidable. It might be erroneous. There might be bases back in 2011 for them to get the Fifth District to reverse it.
Well, it could be grossly erroneous,
Of course.
totally illegal, contrary to 5 different statutes. That doesn't mean it's void.
Correct. Absolutely. And there are in fact lots of errors or things that go wrong that unfortunately, if litigants don't pursue them the way they're supposed to pursue them, or if they don't follow the rules, end up becoming final, and that's what happens.
But this thing, what I'm interested in as far as the fact the sale never takes place. So if you really take, to me, what the bank is saying is even if she had continued to pay after the final judgment, somehow that wouldn't have modified what went on, and they could have just gone and asked the judge to set the sale, or maybe they don't make that argument, but that's to me why this whole thing about the sale never takes place, and as Justice Paulson said, there's mediation. Again, it's irregular because I guess we had a pro se litigant, and I'm not sure where David Stern was during the time this was going on, but it looks like the bank really didn't do what they should have done, which was to reduce the mediation agreement, file it with the court.
Right, and I guess what I would say is, what else was the trial court supposed to do in this situation? There was an agreement that was reached. The bank is the one who even asked the sale to be canceled. You have a homeowner who's coming before the court to say, I'm doing everything in good faith that I possibly can here. I'm doing what they told me, and they're not living up to the deal. And the bank just doesn't show up and stops responding. And in fact, the whole deal that was reached, Justice Polson, at the mediation, the purpose of that deal was to resolve the foreclosure and ultimately end up dismissing the case. And so when Ms. Anthony comes before the judge and she's put under oath and the judge accepts her testimony about the series of events, he can't leave the foreclosure judgment in place at that point. Then the bank could come along at any point in time and say, well, we're going to set this property for a foreclosure sale. So I don't see what other choice here the trial court had under these circumstances, and clearly the trial court had continuing extensive post-judgment authority to do what it did. But again, even if that were not the case, and we wanted to quibble about whether this particular action was outside the trial court's authority, what we're talking about is not subject matter jurisdiction. we're talking about, I think this is, the Fifth District called it procedural jurisdiction. It's some type of issue or error that arises based on the procedural posture of the case or the way that the issue is put in front of the judge. But there's no dispute that this case and these litigants were properly in front of this court and this judge. There's no dispute that the bank and Ms. Anthony had notice of the proceedings. And so at that point, if a litigant fails to pursue the remedies that are available to them, if they
At
don't...
this point, this was 4 years ago that hearing took place?
In 2011,
Okay,
well, 4
and-
years after the original
4 years
judgment.
after the
Right.
proceeding. And there was never any, well, let's see. The homeowner was noticed about the hearing that took place. And the bank was noticed through their attorney that this hearing was going to take place. Is that correct?
I believe that is correct, that
And
the
there was
trial
a-
court issued an order that gave notice to...
And there was never any notice to the court that this was not the attorney of record anymore or anything like that?
As far as the record shows, the bank just stopped
I'm just,
responding.
yeah, I just want to make clear, because the bank did not come to the hearing,
Correct.
correct? And no attorney came, no representative of the bank, no one came to that hearing. And I just want to make sure that
They
the
have not-
record is clear about service to the bank.
As far as I can tell, and Mr. Canigliaro can correct me if I'm wrong about this, as far as I can tell, there's no claim now that the bank did not know that this was going on, or at least if they didn't know, it wasn't because the court failed to give them notice.
Well, they gave one, they say lack of subject matter jurisdiction to order mediation. That's why when the first issue, I don't know how they would lack the ability to order mediation, the sale hadn't gone on, especially if it had been with U.S. Bank requesting it. The second was the U.S. Bank never received proper notice of potential dismissal. Now that, to me, if it's an issue of notice, now we're into why are we worrying about it before this court? So could you maybe articulate, so I'm clear, and I'll ask opposing counsel, what is the basis for our conflict jurisdiction in this case as to what was done that's by the Fifth District that's contrary to other districts in foreclosure cases?
I mean, our view is that there really is no conflict here. I think that the conflict that was alleged in the jurisdictional brief, and as far as I could tell from the argument, is sort of a general conflict with principles and statements about what constitutes subject matter jurisdiction. I mean, I would agree there's maybe some imprecision in the case law about the use of the term.
Are there any cases that are asserted to be in conflict that have factual situations like this or close to this?
I don't believe so, Chief Justice Kennedy. Certainly not that.
Even though there are these kind of broad statements, I mean, would you agree with the characterization of our jurisprudence of related to what's voidable versus voidable as not being absolutely clear?
Yes, I think that's a fair characterization of it. And I think that some courts have recognized that. In fact, Judge Emas noted in the Renovaship case that, in fact, he himself had maybe imprecisely used the term subject matter jurisdiction when that's not actually what he meant. I think that the Pellucci opinion, Justice Pariente, you noted that it wasn't, that there were some cases that talked about subject matter jurisdiction that really meant, continuing jurisdiction or case jurisdiction. But at the end of the day, certainly there's no reason in this case for the court to wade into some kind of discussion about whether, or to clarify that case law at all. Because it's clear that the trial court here had the authority to do what it did. And if it didn't, then the bank should have addressed that 4 years sooner. So if the court doesn't have any further questions, sit down. Thank you.
There was a final judgment entered here. After that final judgment, the court had subject matter jurisdiction in the sense there was this small amount of continuing jurisdiction that allows the court to execute on the judgment. And all the proceedings that happen in foreclosure cases post-judgment are aspects of that execution. There's the sale of the property, perhaps a deficiency judgment. That didn't give the court authority to vacate the final judgment and dismiss the original action, other than through 1.540. And the questions were raised regarding conflict cases, and I'll address what I'm calling the notice issue, the scope of relief issue, first. This court's decision in Lovett, this court's decision in Grace, both held, Lovett expressly, very clearly, said that if the court acts outside the scope of the issues, outside the scope of relief that was requested, then its action is void. In Grace, there was a deficiency judgment that was entered. It was attacked not through appeal, it was attacked through a motion to set aside that deficiency judgment that was filed essentially out of time under the rules at the time for a direct challenge. And this court in Grace went through the situation and concluded that although the court had subject matter jurisdiction over part of the case, what it could not do was enter that deficiency judgment because no one had pled for a deficiency judgment. It wasn't part of the issues that were before the court. And that's the way we use the term subject matter jurisdiction here.
Well, didn't the court there also rely on the fact that really you can't have a deficiency judgment if you don't have a foreclosure? And since the property was gone, there can't be a foreclosure. Wasn't that part of the reasoning?
The court also made clear, though, that you could, under the circumstances, the impossibility circumstances of that case, you could then have basically a money judgment, and that's really what that deficiency judgment was. But it couldn't happen there because it wasn't pled. It wasn't raised. The person in that case, as I recall the facts of the case, didn't go to the hearing, didn't participate in the hearing, and later moved to set aside on this exact ground, and this court said that is the law. And as for the second set of conflict cases, this court's decision in the Shelby Mutual case, where the rehearing motion was filed 32 days after the judgment was entered, this court said that the trial court had no authority, no jurisdiction to reconsider, that the order the trial court entered on that motion filed 32 days later was null, void, and completely without effect. That is absolutely in conflict with what the Fifth DCA did in this case, where more than 1 year after the judgment was entered, we had a 1.540 motion that was filed. We had, just to flesh out the facts, the court sent notice to our then former counsel regarding the hearing. The notice did not say that there would be a hearing on a request to dismiss the action. I believe the court characterized it as a motion to reconsider the final judgment. So even giving everything a generous reading here, the most we have is, and I say notice, it's really about the scope of the relief, but it's notice as well in there. What we had was an understanding that this final judgment might be set aside. We had absolutely
and therefore decided, hey, I'm not that important. Not you, but I'm not going to attend the hearing.
I'll go back to the Grace
This is
case.
U.S. Bank. We're not talking about another pro se litigant.
Whether something is void or not doesn't depend who the litigant is. We're
But
not asking
I
for-
thought you were saying you didn't have notice that something else could happen, even though there had been a subsequent mediation, there had been attempts to a mediation order and pursuit, and no sale of this property had ever taken place.
All true, but none of that is a ground to vacate, not just vacate the judgment, but enter a dismissal of our action in the first place.
But when you got notice that that did happen, then you did nothing about it. Again, you failed to appeal, and but that's kind of an overarching thing.
Your Honor, I'll close quickly by saying that this court's case law makes clear that where something is void for these circumstances, we didn't have to act. We could come later. Voidness can be raised at any time. Thank you.
Thank you both for your arguments.